Some 10 minutes to the top of the hour. You're still watching Joy News here, Multi-TV, DSTV, and Go TV. My name is Benis Abu Bedu. We'll now take you to the Swiss Spirit Hotel, formerly Elisa Hotel, where a GII round-table meeting on the establishment of the Office of the Special Prosecutor is underway. Speaking now is Korea Dodu. He's doing a comparative review of selected jurisdictions with an Office of the Special Prosecutor.
In the exercise of its powers. There are other protections, including ensuring that the term of office of the DPP is a separate cycle from that of the president. So the term of office is an 8-year cycle, whereas the presidential cycle in Kenya is 5 years, 10 years back. That's another way of separating them out so that you don't have a new president who immediately then appoints his own special prosecutor. And there are elaborate grounds for removal, combined with quite narrow reasons that may be used to remove the special prosecutor. So it's effectively like impeachment. Now, what's the relationship between the special prosecutor and the Attorney General in Kenya? Well, it's a completely separate office. And essentially, the special prosecutor deals with prosecution of cases, and the Attorney General is the principal legal advisor to the government. So they've separated it out quite clearly. And the AG has no power to commence or conduct criminal cases. There have been some criticisms, as I say. One is infrastructural. We must have this in mind in thinking about how Ghana's office is set up. The Kenyan office, Kenya is a country which is growing in its stance in the world, its stature in the world is growing. But it still has an under-resourced office which is understaffed, and that leads to a backlog of cases. That really damages the effectiveness of the office. But there are other issues, fundamental issues in the criminal justice system in Kenya, which we see as also contributing to impact on the effectiveness of this office. One is unavailable, uncooperative witnesses. There is no proper scheme for witness management in Kenya as far as we can see, or at least it's not being followed effectively. Lack of available court time, and that includes lack of available judges to hear these types of cases. And Ghana must think about that because we have 2 financial court, high court judges who are well placed to try corruption cases. Is that enough? Our high court judges who try these types of cases are also trying other types of cases, including civil cases. Is there going to be enough space in our courts in the current arrangement to be able to prosecute these cases without a significant backlog? In Kenya, they also suffer from a high turnover of judges and staff, including investigators, which slow things down. If a judge leaves a case, you're going to have to restart the case, because that judge was the person who was going to ultimately decide on the verdict in the case. If the judge has to move to another role or is retired, etc., the case has to start again. So, I'll very quickly look at some of the other systems. South Africa, we found, is rather a complex system and has a lot of problems. The key problem that I'll flag up in South Africa is that it doesn't guarantee the independence of the DPP. There is no formal protection given in South Africa to the DPP office. Some of the criticisms from South Africa is that that system doesn't clearly demarcate between the various investigating authorities. So there's a turf war going on as to who would be responsible for investigating corruption cases. The president also has extensive powers in relation to suspension and removal of the special prosecutor equivalent. And there's an actual case in which that function was used, where the special prosecutor was suspended by Thabo Mbeki, apparently because of a disagreement with the Minister of Justice. Is that really good grounds for suspending the special prosecutor? The Tanzanian system, I will skip through, is fraught with problems, unfortunately. Again, the office there is understaffed and ill-equipped. The office is not clearly separated from the Attorney General's office and has been described by commentators as being likened to a department working under the Attorney General. And the Attorney General has actually been accused of stifling investigations and prosecutions by the Special Prosecutor's Office. So you can see why it's very important to keep the two functions separate. Now, Uganda has a very clean system, and one which actually we could do a lot to learn from. It's a constitutional appointment. In fact, all the systems we've looked at have a special prosecutor who is appointed under the Constitution. There's fundamental constitutional protection. The Ugandan system allows all powers of prosecution to be with the DPP, and there's no relationship between the DPP and the Attorney General. The Uganda Constitution also allows for security of tenure of the DPP. So this is an office which cannot be removed once again unless you have effectively grounds of impeachment. That's a very powerful protection for the office. And then finally, Jamaica. Jamaica, again, is a solid system where the Governor General, not the Prime Minister, who's the equivalent of our President here, the Governor General, who's a ceremonial figure, appoints the Special Prosecutor, acting on the advice of the Public Service Commission. It's a separate office from the Attorney General. He has all the powers, the DPP, to prosecute. And there are significant constitutional protections, including the salary of the Special Prosecutor coming out of the Consolidated Fund. It lacks investigative powers, once again, and again that's been seen as a criticism. So the consensus is that the effective Special Prosecutor's Office should also have investigative powers. That comes out from our research quite clearly. So quick summary of what we've found in our table, and we'll make sure that these research findings are made available to you. All of the systems we look at are created under the Constitution. So none of them have gone Ghana's way of having an enactment of legislation. They founded it in the Constitution. Most, if not all, are appointed by the President, except, of course, for Jamaica. Not all have investigatory powers, but the Kenyan system does, and the Ugandan system does. So, as I say, because of time, I won't go through all the differences. I think the final thing I'll do to wrap up is suggest a few issues that the media might consider in their putting forward recommendations about the Special Prosecutor's Office. I think the media has a unique opportunity to address the accountability of this office. There's an opportunity to ensure that there will be a proper dialogue with the leadership of the OSP, transparency over cases handled, of course, with due issues in relation to confidentiality, etc., taken account of. But there should be a public dialogue over how these cases are actually handled, so that the media can scrutinize whether the office is being effective. And that should also include looking at the budget, the strategy, and the coordination of this office with other agencies. In the UK, the Crown Prosecution Service and the various police forces will issue a press release when someone is arrested. They will also issue a press release when a prosecution is discontinued, so that you understand why the prosecution has not continued. Because there's a public interest in these cases. And so the public should be given the requisite information about the decisions which are made. Again, of course, subject to legitimate confidentiality concerns. There should be interaction with media and civil society regarding cases brought to the OSP's attention. So it may be that members of the media come across issues of corruption which they need to submit for investigation. And there should be a process set up to allow that to happen. And, of course, to think about whistleblowers giving such information as well. We must think as well about the right to information provisions in the RTI bill and how, when those come into force, they will apply to this office. So they need to set up an information officer to deal with freedom of information requests. And they need to be able to provide the information in an efficient and timely way. And I suggest that this office should be public-facing. It should have a website, it should have case information, it should have the ability to deal efficiently with communications with the media and the public. And it should also make communications to ensure that we comply with our contempt and libel laws. Because it's very often the case that media can stray foul of the very tricky contempt laws which can undermine the fair prosecution or prejudice cases. And there's an important role for the prosecutor to play in that as well. So I'll leave it there for now. Thank you very much.
Thank you very, very much. A round of applause. We don't have too much time and so we are going to continue the way. What you have to do, my friends from the media here, this is for you. So put down your questions. There are questions that are very obvious that ought to be answered from the way Ghana is seeking to approach this process. So put those questions down, and then we ask them in due course. For the other speakers, please let me announce to you that the time allotted for each one of you to speak is 10 minutes. I find, though, that because of the nature of the subject, it is so unfair to be giving 10 minutes to do anything close to justice to the subject matter. So when it's 10, I'll tap this mic this way. Have some 2 minutes more. So let's try and manage that. We will now welcome Dr. Drew, who is the Dean of Students and Research at the Institute of Local Government Studies. You know him so well, and maybe you were unaware that he is more than a lawyer by training.
Thank you, Samson, and we thank God for your life. Colleagues, mine is on the media, what the media can do in this regard. When it comes to the media, public interest is important. Our work is to ensure that whatever the politicians or the duty bearers do nears to the benefit of majority of Ghanaians. We speak for the voiceless. The media and the office of the state prosecutor